Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline lawyer. And today's question is, I'm a real estate broker and I'm either buying or selling a piece of real property for my own account. Can I handle this transaction without running it through my firm? The answer to this question is really simple. Don't ask me, ask your designated broker. This is a question that is uniquely controlled by firm policy. And for all of the reasons I'm about to explain, most firms have a policy requiring brokers to run the transaction through the firm. Firms and brokers can work out their own relationship with respect to compensation. I don't care how compensation turns out. The Department of Licensing doesn't care how compensation turns out. The license law and civil liability don't care how compensation turns out. That's a side issue for you to deal with. We're not going to address that again in this film. Instead, what we're going to talk about are the pros and cons of brokers handling a real estate transaction without running it through the firm. The license law definition of real estate brokerage services is very broad. Suffice to say that when you handle your own real estate transaction, you're either the buyer and you handle that transaction as a broker or as a buyer. You find the property, you view the property, you negotiate the transaction, you draft the purchase and sale agreement, you then process the transaction all the way through closing. Or if you're the seller and you're doing the same thing, you expose your property to the market, you bring a buyer into the property, you display the property to them, you advocate the property to them, you negotiate the transaction, yada, yada, yada. You are providing real estate brokerage services. There is no getting around that. If you're licensed and you buy or sell real estate, and representing yourself, if you have your own real estate broker representing you, that's a different issue, and we're not talking about that. But you're handling the transaction yourself, then you are engaged in the provision of licensed real estate brokerage services. Normally, that would mean that not only are you responsible and liable for your actions, but so is your firm. In this conversation, we're going to talk about two different layers of what I would call responsibility and liability. Responsibility is your responsibility to adhere to the Department of Licensing regulations, license law and the Department of Licensing regulations. Department of Licensing, of course, is the Washington agency that oversees the real estate brokerage industry. The other half of that is civil liability that a broker and a firm may owe to a consumer as a result of the broker's provision of real estate brokerage services to a consumer. Okay, the Department of Licensing has said that if a broker represents themselves in a transaction and delivers real estate brokerage services completely outside of their real estate firm, then the firm can avoid regulatory oversight by the Department of Licensing in that transaction. What does it mean for a broker to represent themselves, engage in the purchase or sale of real property completely in the isolation of their firm? It means that you cannot meet the consumer at the real estate firm. It means you cannot give the consumer a business card with the firm's name on it. It means you can't use a fax number or an email address with the firm's name in it. Fax number, I guess, doesn't have the firm's name in it, but the tagline, the receipt line often does when the fax comes through. You can't have a sign in the yard that has your firm's name on it. You can't use letterhead that has your firm's name on it. You can't use forms that are branded with your firm's name on it, et cetera, et cetera. You can't reference the firm in any way, shape, or form. And so long as you don't, the firm can avoid regulatory oversight. The DOL will not discipline the firm for a broker's bad behavior. What if, broker, you slip up, you forget, and you give the consumer your business card with the firm's name on it? Or what if you just pull out one of your forms from your briefcase that has the firm's logo on it? Or what if you just say, look, I'm really busy today. If you would just drop that form off at the office, that'll solve the problem. As soon as you do any of those things, the firm is now entirely responsible to the Department of Licensing to account for that transaction. That means the firm's got to have the transaction log, an entry on the transaction log for this transaction, got to have a transaction folder, the firm's got to be providing supervision of the broker, et cetera, et cetera. So one mistake, identifying yourself as part of the firm is now responsible to the DOL. Okay, set aside DOL regulatory authority for a minute. Let's look at consumer liability, civil liability. The license law says that supervision of a real estate broker ultimately resides with the designated broker for the firm. That can't be avoided. There's no way that a firm can disregard its statutory liability for a broker's provision of real estate brokerage services by not knowing what's happening, by playing ostrich and a firm putting their head in the sand and not knowing what a broker is doing. Even if the broker is the one who secrets away the transaction and doesn't tell the firm about it, the designated broker is still responsible for supervising a broker, so that can't happen. So even if a broker adheres to the DOL requirements to secret the transaction away from the firm to keep the firm away from regulatory authority, the firm cannot avoid civil liability for supervising or failing to supervise the broker's license to the firm. And think about this for a minute. Now connect the dots. If the license law says that a firm is required by statutory law to supervise the broker's license to the firm, and the firm has a policy that allows brokers to intentionally set up, if you will, a screen that separates their activities and their own personal transactions from the firm, in other words, intentionally concealing their actions from the firm's oversight, it won't take much for a plaintiff in a civil lawsuit to prove that the firm failed to supervise the broker if that's what the firm's policy sets in motion. Additionally, many firms have an E&O policy that either prevents a broker from representing themselves, because when a broker represents themselves, they're no longer simply providing real estate brokerage services, which is what errors and omission insurance insures against, but instead they're acting as a principal in the transaction. And E&O insurance does not insure principals to a transaction unless your firm has a separate rider on their E&O policy that would allow that. Secondly, many E&O policies require that brokers be properly supervised by a managing broker in the firm. And so again, if the firm's policies allow the broker to secret away their actions from the firm's management, that in and of itself may defeat the insurance protection that the firm thinks it has by purchasing that E&O insurance policy. So for all of those reasons, most firms that have considered this issue have a firm policy that says every transaction must run through the firm. The designated broker, managing brokers who are supervising a broker must be aware of the transaction. It has to be registered in the firm's transaction log. We have to maintain a transaction folder. There has to be supervision over the actions of the broker. There has to be a proper review of the documentation in the transaction, et cetera, even if it's the broker's own transaction. And then the broker and the firm can figure out what the compensation piece looks like for that. Separate issue altogether. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtor member.